His old friend Frank Roosevelt, of course, serves in the Department of the Navy and then contracts polio and then fights his way back, becomes the governor, gets reelected, and becomes the President of the United States. Jackson waits and declines, but eventually goes to Washington. He believes for a brief stint. He's happy with his life. He prefers this region, frankly. He's done well financially, even in the depths of the Depression. But to serve his party and as president, he agrees to go for about 6 months. Turned out to be the rest of his life. But what a dizzying climb, and just walk with me up this ladder. In 1934, Jackson is appointed and confirmed by the Senate as the Assistant General Counsel heading the Bureau of Revenue in the Treasury Department. Today it's the IRS. He's the head of a 200-lawyer office. It is the biggest law office on earth. 200 lawyers in the Revenue Bureau dwarf the number of lawyers that are in the Department of Justice or any other part of the government and any other law firm in any city. Dozens was a huge law firm in the private sector. Jackson's got this staff of 200. He is a, I think, reluctant and thus, it's related, not excellent administrator is the way I would put it. He doesn't really have the patience to manage a staff and supervise all these assignments and so forth. He really is an autonomous individual lawyer and wants to be doing in government something like what he'd done in the private sector. An opportunity does come along that allows him to give his deputy the management responsibilities and allows him to go to Pittsburgh, where he spends the winter, spring, and summer of 1935. And this is a case, I didn't pull any headlines for you, but in its day it is the big print headline trial of the century. It's not a criminal case. Remember, he's the Assistant General Counsel in the Revenue Bureau. It is a civil tax case. It is the United States of America, represented by Jackson, versus Andrew W. Mellon. Depending on one's view, in the time and in historical assessment, that case was either the long overdue legal accountability brought by the Roosevelt administration to the plutocrats and depredation leaders of Hoover Depression-causing America, including the biggest tax cheat of all, the Secretary of Treasury himself, Andrew W. Mellon, or this was the most gross political persecution, political retaliation, targeting excess of a great American philanthropist, business builder, community leader, at least at that time we'd ever know. Now, you can read many books and come to your own conclusions about this. A couple of tidbits, I think, point me away from what might have been, let's say, the Mellon lawyer's perspective of this case. The judges before whom Jackson is arguing this case is the Board of Tax Appeals. The Treasury has filed a deficiency notice. You've underpaid your taxes, Mr. Mellon. Lots of complicated issues. Mellon files a cross-claim saying, in fact, I overpaid. You owe me millions in refunds. And this goes to trial before this appeals board. It's 7 judges appointed by the Secretary of Treasury. Many of them are deep in their terms, which meant they hadn't been appointed by Henry Morgenthau, Roosevelt's Secretary of Treasury. They'd been appointed by the prior Secretary of the Treasury. Oh, right. That was Andrew W. Mellon. Now, I don't quite know where the recusal idea was in the time period, but that's the bench that's deciding the Treasury's case against Mellon. And Jackson wins. He cleans Mellon's clock. He cross-examines him. Mellon weeps on the stand. It's a brutally effective cross-examination. And then it goes through a further appellate round in which it is settled, and Mr. Mellon passes away. In the intervening time period, he made a final act of philanthropy. You may know that the National Gallery of Art is the collection that was donated by Andrew W. Mellon in early 1937, a personal deal between him and Franklin Roosevelt. There's a great editorial cartoon that has 2 pictures side by side. The United States, kind of Uncle Sam, and Andrew Mellon. And in one case, it's a courtroom where Uncle Sam is prosecuting, and in the other, it's a kind of handshake, hug, receipt of the gift. They weren't unrelated. One of the tax fraud counts in the case that was decided against Mellon was deductibility of art donations to various corporate entities by him that somehow didn't result in the paintings ever moving from his apartment walls. Franklin Roosevelt makes this deal, the case gets settled, the Mellon and estate makes a payment, and Franklin Roosevelt, for the rest of his life, referred to that National Gallery of Art as Bob's Museum. Now, from that success, Jackson is, in a good way, a marked man. He is the inner circle, trusted legal talent who has risen to that rank. And this is the cover of Newsweek that December of 1935. This is Jackson and James Landis at SEC at the time. The third fellow is an obscure lawyer. And they are defending the constitutionality of the Public Utility Holding Company Act, one of the leading New Deal statutes that was under incredible constitutional attack and headed for the Supreme Court that was very hostile to the New Deal. They win that too. And then Jackson moves over from that sort of interlude from Treasury, which was still formally his employer, to the Department of Justice. And here are the steps there. 1936, he's heading the tax division in Justice. 1937, he's heading the antitrust division. 1938, he's the Solicitor General of the United States, and he gets this office and this desk. And he argues more than 40 cases before the Supreme Court during the 2 years he's Solicitor General and wins almost all of them. Now, admittedly, the court had changed with Roosevelt appointments, but Jackson's forensic skills were extraordinary. Louis Brandeis, Justice Brandeis, said Jackson should be Solicitor General for life. And after 2 years as Solicitor General, that's him working at the SG's desk, he becomes the Attorney General of the United States, where he serves for 18 months, 1940 into 1941. All of that is a trajectory in the second term of a president who was inclined to observe the great American tradition of going home after 2 terms. Franklin Roosevelt began his presidential library in 1937. He signed an employment contract to be a magazine writer, a $50,000 a year contract in 1938. That was, before it was required, the tradition unbroken, and he intended to keep it, which means the New Deal process, that's the court of 37, that's Jackson as AG. The New Deal process has to find a next standard bearer. And 39-40, in the early months of that year, I think it's fair to say that Jackson's the man. This is a poster, and this is a magazine article, and there are legions of them. One of the errors you'll find in the introduction I wrote to that man is me being dismissive some years ago of this Jackson for president thing. I've actually come to understand how huge and real it was. It deserves to be dismissed by May of 1940 because the world had changed. But it was extremely real in January, February, and March of 1940 when Hitler was not on the march, when France was not about to fall, when Roosevelt was still playing coy but likely to go home, and the New Dealers were going to fight the machine city leaders at the convention but try to get the nomination for Jackson. Of course, his path went in another direction. This is a joint session of Congress that spring, where Franklin Roosevelt is asking for a huge military appropriation to build up our Navy, to build up our air defenses, to prepare for involvement, at least in a support role, if not directly, in the European war that's now exploded. And Jackson, instead of going to a convention and becoming a nominee, becomes a justice. Roosevelt, after re-election, has an opportunity to appoint 3 justices in one move. Jackson, at age 47, is appointed an associate justice, and you see him in the rookie position at the far back corner of this picture. He serves on this court from 1941 through 1945, the spring of 1945, 4 terms. And during that time period, he builds the reputation of incredible writer, independent thinker, not captive to any particular camp. He writes West Virginia Board of Education versus Barnett, which strikes down the compulsory flag salute, which had been imposed on Jehovah's Witnesses, who had a religious scruple against it. He dissents in the Korematsu case, which was the exclusion of Japanese Americans on military order from the West Coast. He's working to sort of make the mental shift, if you will, from private practice and partisan identity into judicial form.